of the um, the need for it. I think we, as a chapter, saw it necessary to have this meeting so that we can look at the implications of Section 44, and Jean Paul will go through it with us. And then after that, I think we need to have some discussions around our problems that we currently have. And I think all of us have problems with the lines, and we want to ensure that we, as a collective, make a decision as to which way we're going to go, because we find the lines is not willing to apply the amendment to the regulation. So before I continue, let's hand over to Jean and let him go through the background and through the letter that you see here. And then from there, we can take questions and comments. And if you feel you want to comment on anything while he's busy with the presentation, I suggest you put up your hand and we'll note it, and then we'll come back to you in that order. Okay. Thank you. John, over to you.
Thanks, Alan. Afternoon, everyone. Firstly, I apologize for not preparing a formal presentation. Paradoxically, I decided not to because of the great interest shown in attending this meeting, because I realized when I saw how many people were attending that there's obviously a problem, I mean, with the shipping lines. I would like you to, if anyone has had success in obtaining release of your stopped goods from the shipping line for the purpose of transport to a container depot or any other designated place of examination, I would like you to mention it in the chat that you have had some success. If anyone has, yeah, so this is simply so that we can all be on the same page and, you know, look at what that may have entailed. Okay, so it was about on 30 March 2019. I'm just going to run you through the history first of this legislative amendment, where it started, and how it started. So on 30 March 2019, we basically had a so-called SAF Bosberaad, where we looked at the strategy for the rest of 2019, and also projects that we would like to tackle with SARS in terms of legislative amendments. And one of the topics discussed was the excessive line charges raised for moving stopped goods to a container depot or through the scanner. And the obviously the lift off and lift on charges, those kind of charges, you know, that are all related to the movement of your stopped goods for the purpose of customs examination. And what we then decided was to basically make a submission to SARS head office, proposing some changes to the legislation, whereby the control would be placed back into the hands of the declarant to take charge of the movement of his or her stopped cargo from the terminal to the container depot, you know, of the agent's choosing, basically. So I drafted the basically the submission to SARS head office, which was then presented at the next National Customs and Excise Stakeholders Operations Forum which was the following week, the next Friday. We then received a response from SARS head office stating that what we're proposing isn't provided for in the Act, in the Customs and Excise Act, but they understand our problem and being these excessive charges, and they will be looking at amendments to the legislation. But for them to accommodate us, we'll have to wait until budget 2020. The fact that we had to wait until budget 2020 told me personally that the process that SARS is contemplating, the changes that they are contemplating to the legislation, would entail some systems enhancements, and they didn't have the budget for that, because there can't be any other reason why they would want to delay it for almost a year to February 2020. And to then provide for this legislative amendment in the budget. So in 2020, February, during the budget speech, there was a budget review section where this proposed legislative amendment was mentioned. And it was stated that basically when goods are stopped, there would be a provision in the Act, or an amendment in the Customs and Excise Act, that would allow you they would basically permit a licensed remover of goods in bond to take control of the stopped container from the shipping line, thereby discharging the shipping line's liability, to then enable the remover in bond to remove the goods, the stopped goods, to a container depot of the declarant's choosing. So in other words, it's basically a conditional release to enable the use of merchant haulage, which would then stimulate competition. And because obviously if the shipping line as the sole mandate, then they can charge whatever they like, and that's basically what they have been doing, and then in the process, basically lumping on excessive charges, which can in no way or manner be justified, except obviously by a monopoly. So then, on 31 July, SARS published their draft tax administration laws amendment bill for public comment in 1 month by 31 August 2020. The bill included the proposed legislative amendments to the Act, which was essentially that for the purposes of transport of stopped goods to a container depot, the shipping line's liability would cease on release to a licensed remover in bond. So I'm not sure what public comments were received, but none were received apparently from the shipping lines, who it seems missed that draft bill for public comment. So the bill was finally published on 28 October, set to be ratified by Parliament. And on 20 January 2020, the Tax Administration Laws Amendment Act was published, whereby this provision was then made law. But then, for several months, there was no change or no movement until it was raised at one of our EXCO meetings, as to the status. So when I investigated, I realized that, in fact, the law had changed on 20 January, but SARS, in the process, had made no systems enhancements. It was a very simple process that they basically introduced, I think that SARS must have basically considered some legislative amendments, some system enhancements, but decided against it. And because that's the only way to explain why the process would be delayed for almost a year and would have to be budgeted for in the 2020 budget, you know, the SARS budget. So, which then brings us to the actual requirements for you, at least in theory, to obtain release of your stop container from the shipping line for the purposes of moving it using your own merchant haulage to the scanner for non-intrusive inspection and or to a container depot of your choosing, any licensed container depot of your choosing, for the purpose of physical inspection, including full unpack examination if needed. So essentially, the process is very simple. You basically apply for release from the shipping line of your stop container. And when you do so, you then nominate a licensed remover in bond with a current license. And as part of that application, you provide an up-to-date or current license of that remover in bond, which is your trucker basically, but the person has to be licensed and has to have a current license qualifying them as a remover in bond. Security does not figure into this equation because the process does not entail amending your declaration first to insert any remover in bond details on the declaration, which would then basically attach a security requirement to the stop. And I think the reasoning behind that, I mean, if I put myself in Sars's shoes, is simply that a customs declaration has or will have been made already in the vast majority of cases, which means that the duty and the VAT is secured, you know, for payment to SARS. So all that remains to be done is for SARS to obviously verify the validity of your declaration. Juliet, if you can just scroll that screen a little bit of that letter. I'm just going to see here. I think it's probably on the second page, Julia. Just scroll on a little bit. Yeah. So if you look at the bullet points towards the bottom, please also note the following. The containerized goods are to be transported for the purposes of examination contemplated in section 4.8a. Section 4.8a, 8 capital A, basically deals with normal stops of goods for the purpose of customs inspection, whether it's done via the scanner or physical inspection, regardless. And this implies that due entry of the goods has not been made, and there will be no customs release for the goods at this time. So if we look at the actual amendment, it basically talks about release of goods after due entry has been made by the shipping line to the importer or his agent. And the alternative is, which is where the amendment comes in, is when due entry has not been made yet, then the line must basically release the goods on application to a license remover in bond. So looking at that, So essentially, when you make a declaration to customs in terms of section 38(1)(a) or any other provision, you are basically making due entry, or you are basically making a declaration which suggests that your entry is correct and valid in all respects. But obviously, customs can challenge that. And for the purposes of that challenge, which is the stop, customs deems that you have not yet made due entry because your declaration is now subject to verification. So I think that is the reasoning behind in the way that SARS introduced that specific piece of legislation. So then all that remains, when you apply to the line for release, you should cite the section of the Act and provide a copy of the current remover in bond license of your, for your trucker, your nominated trucker, and for the trucker then taking this conditional release. I think that if everybody's agreeable to it, or if you think it's a good idea, I'm quite happy to put together a draft template which can be used going forward, maybe by the entire industry, to apply for and obtain release from the shipping line. Okay, so now the way forward, as I understand it, the lines have not been giving release. They basically refused point blank to give release on this basis, conditional release. We had a meeting yesterday, being the expanded stakeholders meeting with SARS. Not sure how many of you present attended that, but many of the lines were in, so we invited all the lines, in fact, via Peter Besnard, the CEO of SASAWA, to attend yesterday's expanded stakeholders meeting, and many of the lines did in fact attend it, MSC included. The shipping lines kind of caught us a bit off guard in the sense that they mentioned that they had made representations to SARS dated 28 May via email to Marina van Twisk, setting out their concerns. So at yesterday's meeting with SARS and the shipping lines and the depots and truckers also, or I think a couple of trucker associations, we requested to have sight of those submissions. The lines were reluctant to share those submissions. So Basil Hannibal, our staff consultant, has submitted an email to SARS head office, to Marina van Twisk, who's head of the law amendments for customs and excise, inquiring as to the contents of the submissions from the shipping lines, and requesting that those concerns be shared with us. But at yesterday's meeting, we unpacked basically what the concerns of the shipping lines were, because at the meeting I invited them to basically air their concerns, and only two concerns were actually raised at the meeting. And the first one was that the lines are apparently concerned that once they lose control over the shipment by giving release to a licensed remover in bond, they are concerned that the container, I think, higher fees and other miscellaneous charges may not be paid. And one of the concerns they raised was what happens where the goods are removed to the container depot for physical inspection, and as a result of subsequent developments, the goods or the importer or the principal decides now to abandon the goods to customs. So we addressed that concern at yesterday's meeting, in that we pointed out that the Customs and Excise legislation provides that no final release of any goods may be given until such time as the shipping lines, charges, including the container hire, has been paid in full. I mean, this is provided for in the Customs and Excise legislation. So essentially, the way the process works is the shipping line obviously has control and is in charge of the goods, and is also liable for the duty and the VAT once the goods are deemed to be imported in terms of Section 10. Then the line may give release on application, or must give release on application, to a licensed remover of goods in bond, at which time the full liability for the duty and the VAT and for the goods is then vested in the licensed remover of goods in bond once lawful delivery has been taken in the terminal by the licensed remover of goods in bond. The licensed remover of goods in bond will then remain liable for the duty and VAT and any other costs and charges until such time as those goods are then delivered to the container depot or any other designated customs area for the examination of those goods. Once the remover of goods in bond has delivered the goods to a depot operator, which is basically a container depot, or other designated appointee, the liability transfers from the remover of goods in bond to the depot operator, in other words, container depot. So then the depot becomes liable for all duties and VAT on those goods and for any other charges. And obviously the depot is then not permitted to give final release of those goods until such time as all costs and charges that are legitimately due have been paid, including those charges which are due to the lines. The second issue that they raised was whether the lines would still be responsible for the final acquittal of the goods, I think, in those containers. And the answer to that, which I also provided yesterday at the meeting, is no, because the Act is quite clear that the line's liability ceases once the line gives release of those goods and lawful delivery is taken by a licensed remover of goods in bond. So those were the only two concerns raised by the lines, and both those concerns were in fact addressed at yesterday's meeting. But obviously we do need to also have a look and see what are the concerns that the lines have raised with Sars head office. But I would also like to stress that regardless of the concerns raised by the shipping lines to Sars head office, the law is the law. And the lines have got no good reason or lawful basis for refusing to give release of stopped containers to you as the licensed clearing agent, obviously through the person who actually takes delivery of the goods from the terminal, who must be a licensed remover in bond with a current license. So that basically is it. Just want to see if I've missed anything. Yes, so that basically brings me to the end of my presentation, which is a bit informal. So apology for that once again. So now I would like to open the floor and basically listen to or hear what you have to say, comments, problems that you've been experiencing. What do you propose? I should also add that we did have a special meeting about a week ago in preparation for yesterday's meeting with SARS, where we discussed, a part of our executive committee here in the Western Cape discussed what strategy we should adopt for the purpose of yesterday's meeting. And at last week's meeting, we did consider the possibility, of what are our options if the lines continue to refuse to give the release in terms of the law of the stop goods to licensed removers of goods in bond. And obviously, one of the options is litigation, which SARF can undertake via William Fullard, which is SARF's designated legal representative. But normally litigation is a very costly affair, and I speak from personal experience. I've been involved in a lot of litigation over the years with customs in terms of appeals in the High Court on various matters, and these things always tend to drag out, and it goes on for years before you see any, any final result in terms of the judgment from the High Court. Obviously, one can lodge an urgent interdict. That's one option. But as I mentioned, litigation is normally costly, and you've got to give the other party a chance to respond. So it's all basically drawn out process. The other alternative, which we considered at last week's special meeting, was the possibility of obtaining Sars Assistance. And what we considered was approaching Sars head office and getting them to basically load a message on the declaration system, an automated message where goods are stopped. So then your stop note notification will read that the goods are stopped for physical inspection or for scanner, but there'll be an additional message which will read something along the following lines: that conditional release is hereby given to any current licensed remover of goods in bond of the declarant's choosing for the purpose of transport in terms of section 4, subsection 8, capital A. And the thinking behind this specific proposal, this enhancement to the messaging system, is the fact that this is more or less how things were done historically about 10 to 15 years ago. You may all recall that at that time, there was a manual stop process in place. Obviously, as time went on, it became more and more electronic, and with the stops becoming electronic, but the release process still being kind of manual and using a DA-74. So when goods were stopped in I think 2008, 2007 or before, basically you as the clearing agent would take would complete the DA-74 and take it to SARS, and the DA-74 would basically state that conditional release is being applied for from the line and for the purposes of merchant haulage of the goods to the container depot. And then you can obviously, then you could remove the goods using your own merchant haulage to a licensed container depot for physical inspection. That's how it used to work. But when SARS introduced the electronic system about 2009, 2010, 2011, and this system of obtaining a conditional release from the shipping lines fell by the wayside. And SARS basically left out this possibility that you, as the clearing agent, could remove the goods using your own merchant haulage, and that part of the process basically got canned. So for the last 11 years, the shipping lines have basically had a monopoly, or you could say the sole power, so to speak, over the stopped goods, whereby they became habituated to the idea that they are the sole authority in charge of the goods. So by approaching SARS head office and asking them to introduce such a messaging system, we would basically be sensitizing the lines to the fact that they cannot simply automatically remove the goods to the scanner or to a container depot for physical inspection, but basically must await your instructions as the declarant as to what you want to do. Do you ask them to remove the goods, or do you apply for release so that your license remover in bond may remove the goods to a container depot of your own choosing? So that's basically the idea behind that suggestion. A third idea that came up at the meeting last week was that we should ask SARS for their intervention. Obviously, the line's refusal to provide the release on application is in contravention of the Customs and Excise legislation, which SARS is designated and appointed in terms of the law to apply and enforce. Therefore, the refusal by the lines to give you the release is a matter that can be addressed with SARS as a third alternative, asking SARS to basically take action, administrative action against those lines who refuse, as SARS may deem necessary and appropriate in the circumstances. So those are the three options. And yes, on that note, I would like to open the floor and hear what you think, how you think the matter would best be progressed to resolve this kind of almost like a Mexican standoff in the simplest, most appropriate, and obviously cost-effective a manner as possible. So I'll open the floor accordingly. Thank you, everyone, for listening.
Okay, John, there's a couple of messages on the chat line. Okay, the first one is from Rowan. Okay, I suppose the line would give a letter to the clearing agent confirming that all charges are paid, similar to the state's warehouse release. I suppose they would do that because what you would have to do is you will have to take the necessary documents with your customs bill of entry, with your bill of lading and all the normal documentation with the charges up to that point. And then based on that, they should then give you release to move that cargo conditionally until final release is done. So I suppose if you haven't paid, if there's any current outstanding charges up to that time, they won't give you that release. So it would be like a normal release that you go and go to the shipping line for.
Yeah, and then I see there's one from Tishan. How or what document will we need to submit to the line? So responsibility moves from the line to the remover in bond holder. As I mentioned, I think that one should apply, on your letterhead and cite, cite the relevant provision in the Act. As I mentioned, I can draft a kind of a template, and we can look at it and move it through the necessary approval process within SARF to the extent necessary, and then that can be used together with a copy of the license remover in bond, your trucker's current license, and submit that to the line as part of that of the application process for the release of your container, of your stop container. So that I would suggest. And then from Joy, how do we enforce this as it stands? What process in terms of systems, VOC, inserting, removing bond, we process service manager? No, we don't do any of that, Joy, or anyone else who's curious about that question. We simply, I thought that SARS would introduce something of that nature, such a system. And I thought that was the reason why they wanted to delay the process to basically get necessary budget so they can do their system enhancements. But consider this, if goods are stopped and you now first have to pass a VOC to insert remover in bond details, that would substantially delay the process of getting the goods physically inspected, which would be almost self-defeating. It would basically drive the costs further. And that's, I think, is probably part of the reason why SARS head office decided not to make it as simple as possible by simply making it a normal, seamless application process to the line in which SARS would not be involved in the form of anything that has to be done on the customs declaration. Yes, so then Tishan, secondly, in terms of cost, sorry, does anyone have a comment?
Yeah, I think in terms of this, you would then negotiate your own cost with the depots, because you would nominate a depot that a customs registered depot that would be able to do your unpack. And that cost will be for your account, okay? Because at the moment, the shipping line dictates where it goes. They charge you according to their tariff, and they have a special tariff. So part of the reason why the application was made for an amendment was the cost, because the line's cost is quadruple what you would normally pay. So the idea would be is that if you negotiate with a depot that is a customs registered depot, unpacked depot, and your exam can be done, you move the cargo with your nominated remover in bond, licensed remover in bond to that depot. You then that cost must go directly to you as the trader or as the agent for the importer. So that is the idea that how it should be applied.
Yeah, and that answers Tishan's question, where he says, secondly, in terms of costs, yeah. Shipping lines have agreed rates with certain depots. So who is responsible to settle depot costs? The answer is that if you get release from the line and you nominate the depot, then you're responsible for settling your cost for the depot. It's no longer under the control of the shipping line and that process, and therefore they can't charge you their costs to the depot because you're now basically managing that process. Okay, is that clear? I hope it's clear. And then Tishan also mentioned also removing bond is for agents who pass the bill of entry. So if you're subcontracting, does the RIB still apply? Won't the consignor bond be the correct option? I think the answer to that question is whoever the trucker is, must be the license remover in bond. In other words, whoever removes the goods, whoever you appoint to remove the goods to the depot is going to have to be a licensed remover of goods in bond. And that company doesn't have to have a lot of security as such. It doesn't even have to have any security. In fact, it's not a requirement in terms of the legislative amendment. And as I mentioned, I believe that this is because you've already made a declaration to customs, and the duty and the VAT, in terms of your declaration, is secured on that declaration. And should customs find faults with the goods during the physical inspection, after the goods are released by or delivered by the remover of goods in bond to the depot, should customs then find fault with your shipment, their message and their request for additional duties and VAT and forfeiture, whatever they want to impose, is going to be to you as a declarant. And you've already basically put yourself in that line of responsibility for any additional duties and VAT that may be applicable, and any penalties and forfeiture by making the declaration. So I think that is the SARS reasoning behind not bringing this any security requirements, for a license remover of goods in bond into the equation. So that means that your consignor bond or your would never be applicable unless you, as consignor remover in bond, is basically removing the goods using your own trucks. Only then would you submit your consignor remover in bond current license to SARS. Otherwise, you would have to basically submit the current license of your actual trucker who is taking physical delivery of the shipment from Transnet, from the Transnet port terminals. Johannes, for the bonded carriers on this call, how do you feel about being responsible for the duty and VAT until such time the container is delivered to? I think that's actually a slip of my tongue, Johannes. Remember now, we've basically essentially before the goods are stopped, normally you would first make a customs declaration, and you basically, by making the declaration, you're basically declaring that you are liable for the duty and the VAT. You're claiming the goods or an interest in the goods, and you're declaring a principle on the declaration. So technically, the duty and the VAT is actually secured by means of your customs declaration. So the duty and VAT provision for the remover in bonds being liable would only come into play where a customs declaration has not yet been made. For example, but that I don't think that scenario would ever arise. It would be very unusual for that to arise. Yes, so I think I've answered that question. Then Joy, am I correct to assume the customs systems enhancements are not ready? No, there's no manual process. Claudia, who's Claudia from CMA? Is she on this call?
Now, Claudia said that she had a shipment in Port Elizabeth through CMA that was released without any issues. So what Joy's actually asking is for Claudia to elaborate on how that process worked. Don't forget, you asked anybody in the beginning, you asked if anybody had such a release already.
That's right,
Claudia,
yes.
So Claudia said yes, they had. So we'd like to hear from Claudia. Thank you.
Okay, over to Claudia. Is Claudia on the call?
Jean, I don't see her in the list. She might have dropped.
Hi guys, Jan here, B office. Claudia was kicked off for some reason.
Okay, but
I'm not sure what the CMA issue was. While we were talking, she thought it was because the shipping lines was now as that you have to submit your release documents 24 to 48 hours before release. Otherwise, they move it to their depots. I think it might be something around that and not the current discussion that we are having.
Oh, but regardless, I mean, if anyone had success, it basically is a very simple process, as I explained it. It doesn't involve customs at all, and no systems enhancements are needed. You basically apply, I think, via letter to the shipping line for release, and you provide a current license for your trucker, remover of goods in bond, who will be picking up that container from the port authority. And that is the process. It's very, very simple.
John, just something else. I understand this whole thing. So this is basically to speed up your process from getting a container stopped and moving it to a depot for inspection, to not have delays from the shipping lines through that type of thing.
That's right. And also not delays from SARS. I mean, if they had to introduce a system enhancement, it would basically mean that there would be now two processes. They would issue a stop notification. Now you've got to pass your VOC, which might take another day, and then another day for them to come back to you and give you the conditional release. So I think that SARS decided against that approach. But they must have considered it, because that's why they asked for, why they said they can only basically do these changes after budget 2020.
Yeah. Okay, but just on a maybe a similar but different note. We've got a situation with Maersk where a container was stopped and then moved to customs depot for inspection. Container was fully unpacked, but Maersk refused to allow turning of the empty container. Why? Because I had the only shipping line that does that, as far as I know. Because I had to stop like the next week, and MSC allowed me to turn the empty container in. And I'm now having a big fight with Maersk, because obviously the marriage and the tension charges are out of the world.
Now, why did they refuse to turn your container in? What was their reasoning around it, Jan?
They just said that SARS has not released the shipment. The container is linked to the shipment. Therefore, they will not allow me to turn the empty in. And I went back to them and said to them, look, the container is only a vessel of carriage for the imported goods. The goods has now been removed from the container. Therefore, the container has no bearing on the goods either or.
I agree with you about that. I agree with you about that.
To turn it in.
Yeah, no, that's nonsense, and they need to be addressed on that issue. Definitely. I agree that that's nonsense, because the container is merely the means of carriage. Once the goods have been unpacked at the depot under customs supervision or by the depot, you must bear in mind that depots are licensed for the express purpose of unpacking goods from containers and packing goods in other containers. So the depot is authorized to unpack goods in a container depot from the container. I think that when goods are stopped, then they will obviously wait for customs to show up to break that seal. But once that container is unpacked, fully unpacked, the shipping line has no claim over any further storage charges. You're entitled to turn that container in, and if they refuse it, then any additional costs would be for their accounts. I wouldn't pay it. Basically, I would refuse to pay it.
Yeah. Look at this stage. I had to pay. Obviously, I had to pay it, but I have put in a grievance into the shipping line. And I'm now waiting for their response on it, because I asked them, please give me the legislation that gives you the right to refuse my empty turning.
Yes.
Thank you.
John, if I may.
Yes.
Okay. The rationale and the purpose of us having gone through all these lengths to move to have this legislation put in place was precisely that, because of the costs. So currently, when I say currently, before this legislation came into being, or the law came into being, a stock container would cost you anything between 7,000 and 10,000. Okay. You are now able to eliminate all those costs if you are in a position to move your own containers to the depot. Don't forget, the shipping lines will delay the movement of your stock containers to the very last minute, so that you do not get an appointment the next day for a customs to come and inspect the cargo. That's where all your costs are accumulated on. So with this new legislation, you are now able to collect your own container from the depot, from Transnet, move it to the depot, have it placed on a stop list, and you can have a container done within 3 days. That is possible, very, very possible. I can further tell you now that on Friday, we will hear from Ashika Pillay, the C modality chief. She is looking at the reintroduction, or looking at the depots processes where and who arranges stops. If you go back in time, a year or two ago, we were able to make our own bookings once the containers have arrived at the depot. But that was taken away from us. Okay, and the depot now makes the arrangement for a stop with SARS. But if that is reversed, we can now be able to do what we've done before. Collect your own container when it's in the depot, make your own arrangement with SARS for the inspection that can be done the next day, get your container released, and there off you go without any hassles. Thank you.
I see Joyce also has a question. Are the depots aware of this change in legislation? I don't know. The reason I ask this, no depot commented in yesterday's meeting. Not sure if what depot was present. Does the Basil, do you know who was present from the depots? Juliet? Do you see anything?
I'm not sure, Jean. We had a big audience, so I'm not quite sure if the depots were there. I mean, I know that SARS did invite the depots.
John, yeah, there was a couple of depots that was present. They two actually phoned me today to get some further information on it, because what they didn't comment because they felt they needed to get some more information, because they also feel that the lines have preferences. So SACD is one of the depots that get the majority of stops, and that also causes a problem for making appointments, because they cannot handle it, and therefore the other depots felt that they have the capabilities, but they never get support from the line. So there is depots that is looking at also going out and challenging the status quo with SACD, and trying to provide a service to industry as a whole as well. So depots are aware of it.
Yeah, and just to add to you again, Llewellyn, it's about the costs. So somebody asked earlier about the shipping lines and their contractual obligations with the depots. Well, that falls out by the window now, guys, because you cannot choose your own depot. You don't necessarily have to go to a depot that is aligned with the shipping line that will charge you an arm and a leg. You can now actually negotiate with SACD, as an example, your own rates with that. And bear in mind, as you earlier mentioned, Llewellyn, if the depot charges 200 Rand for a lift on, MSC will charge you 400 Rand. So that's where all this whole thing comes from. Thanks.
Yeah, so I haven't seen anybody saying what they propose or what might be the best option. I've sketched three. The one is litigation. The second one is enhancing the SARS messaging system. So just introducing a line there on the stop note to basically sensitize the lines to the fact they're no longer the men of the 10 years. They basically have to take instruction from you as a declarant as to what you want to do with the goods, or whether you want to take release of it via your nominated remover of goods and bond. And the third option is to ask SARS to basically crack down on the lines if they continue to do this and refuse to take release. Then we would have to obviously set up, probably ask SARS to kind of set up a command center maybe, to which complaints can be submitted. So that SARS can then directly address the lines on those issues and basically, you know, threaten them to the extent necessary to force them to comply with the legislation. That's the third option. So if you don't want to say anything here because you suffer from stage fright, like me, then please, I think, email Juliet after the meeting with your suggestions, and we can then take it from there. I also would like to know what you think of my proposal of getting a standard template in place to take release from the line. I can draw up something and then we can have a look at it as the SARF Exco. So if you don't want to say anything, put it in the chat or send an email to Juliet, whether you agree or disagree, and we'll take it from there.
Okay, just before you close off, John, or before Llewellyn gives his last reply, Trishan, to your last point there. Okay, so why does the depot make the booking? So okay, let me explain something to you. Previously, we were allowed to make our own arrangements or own bookings, and more than 50%, if not, yeah, more than 50% of the time when the booking was made, SARS complained that the goods weren't available for inspection, meaning that you made a booking with the foreign inspection at the depot and your cargo wasn't there. So that's why they reverted or took that away from us to make that the reasoning that the depots would actually, in actual fact, make the booking, because the container would in fact be there. They can't make a booking if the container is not there. But with this legislation, if your transporter moves the container to the depot yourselves, you would know that the container is there and therefore you can make the booking. Okay, does that answer your question, Tishan?
Okay, I think it's now 10 past. We are about the hour, and I think you know, just to maybe sum up, I think what we need to do is we should approach SARS with an idea of putting a message in, as we discussed in our Exco meeting, and maybe look at that avenue from a SARS perspective, SARF perspective. And secondly, we will maybe look at the standard document that we can draw up through the SARF Exco and see what document we can put out there. Remember, this is a national issue, so we have to use something that is national. Okay, so maybe we will go to SARF National also and get their input, and that we have our legal protection from our legal representative on the SARS board. And then thirdly, I think we need to maybe as a association, we need to look at where we can support and help each other. And I think what we need to do as members, we need to share what information we have. So if anybody has had any success with this legislation, that your container was handed over to you, then share it also with Juliet and send it to us so that we can see if it's all the lines that is kicking up against it, or if it's only certain lines, so that we can maybe then see use a different approach by consulting with these lines and finding out what is the reason why they are doing it. But if it's everyone, then I think then it has to be a different approach. And I think we, because at the end of the day, we look out for the best interest for our clients, and they are the people that suffer. But ultimately, all of us suffer because whatever charges is lumped up on the shipment, ultimately it will affect the man in the street, you and me. So I think we need to be very strong and vigorous about this. This is an issue that the lines is not going to give up lightly. They are going to try and get away with it, and we need to ensure that they do not do it. Okay, so I think maybe to summarize, I think what we should do, Jean, we will look at the option of asking and approaching SARS to see if that message can be adjusted to basically give us, when a stop box is sent, a notification is sent, that message, as we discussed in our ESCO, could also be included. And secondly, we will then also look at standardizing a form, and then maybe also see if we can consult with the lines again and see what comes out of that discussions. And then maybe we will have a follow-up to come and provide feedback to everybody at large. Okay. So thank you very much for those who are here. Thank you for your time. I see Claudia is back. Claudia, maybe we just check up with you. I don't know if we misunderstood you, but have you moved a box that was stopped by SARS and the line gave you the option of moving that box yourself to a depot?
Hi, Llewellyn. Sorry, I don't know why I was kicked off. No, sorry, I jumped the gun there.
Okay.
No, we haven't. Sorry. No.
Okay.
We haven't had any luck with that. Thank you.
Thank you. Okay, that's it. Thank you. If anybody else has got any other comments before we close and say goodbye. Vincent has got his hand up.
Thank you very much. This is just input from me. I fully agree with the options that were put forward for a manual template, but I'm seeing that as a temporary solution. You know, if you go back to the reasons why the electronic releases were introduced, it's because there were fraudulent activities that were taking in trying to eliminate the risk. Then SARS came up with digitization, etc., etc. So for me, long-term solution around this issue is when the shipment is stopped and an embargo release has to be requested and granted by SARS. The solution lies in the enhancement of the system by SARS so that the shipping line will know that indeed the authorities have granted the release. Because if we will go back to the paper physical documentation, there was a risk why they've been moving away from manual documentation and manual releases. Thanks. That's my input on that point.
Yeah, I think Vincent, thank you for that. I think just for clarity, okay, the notification will still remain on the SARS communication. The only manual document we are referring to is the one that you take to the line to say, with the document from SARS that says, okay, we can, if the message should read from SARS that you are allowed to move the container with a license remover in bond, that SARS notification with a manual document from ourselves as the agent to the shipping line to say, okay, this container we want to move with our own merchant haulage to the depot of choice. So the document would technically only be to the line, and it would be from to basically confirm that the nominated remover in bond has a license, and this is the license remover, and with a copy of his license. So that would be the manual documentation. Okay. Any other comments? Any other before we close and close the meeting off? Okay. I see there's no further hands or any further comments. So thank you very much to everyone. Thank you to Jean for the presentation and for his time. And thank you to all of you for your time. And I ask you nicely and kindly to keep us informed of any developments. And if there's anything, if anybody has success, maybe just pop Juliet a mail to tell her so that we can also have that information on hand. Okay. Thanks all. All the best. Have a great day further.
Thanks, Lou. Thanks,
Thank you.
John. Thanks to everybody.
Thanks,
Cheers.
everyone.